The division of marital property in the state of Michigan is handled through doctrines of equity, essentially. Michigan is more a communal property state than not. So what you have to understand in the state of Michigan, if you're a married person, everything you've obtained or come into ownership of, or that's become a liability for you after you've taken your wedding vows, is joint property typically, unless it could fit into certain exceptions that are oftentimes very limited. So one of the exceptions could be an inheritance. The other exceptions would be gifts. But other than that, any property, debt, or liability the married couple has come into as a married couple will be divided equitably in the state of Michigan. What is equitable distribution in Michigan? Equitable distribution does not necessarily mean 50-50, although as I've said prior, once parties are married, every debt, asset, and liability that they come into contact with is a marital asset, piece of property, or liability. The courts will try to help the parties divide those things, and you would probably be best advised to start with the 50-50 presumption. With that 50-50 presumption comes certain exceptions, and this is where the facts come in and case law comes in when there are certain circumstances at play in the marriage that may justify different divisions that are not 50-50. Maybe that'd be 75-25 or 60-40. At that point is where it depends on the facts of the case and what your clients and parties are seeking. Typically, assets and debts are divided in Michigan. Again, they call it equitable. So you start on the wedding date. Assets and debts before the marriage, we haven't talked about that yet, are oftentimes going to be considered sole assets in debts. Now, this is where it gets a little bit complicated, is those even premarital assets and debts could be commingled with the marital estate, and oftentimes they are commingled with the marital estate after the marriage vows. Separate property has then just become marital property. The marital property is then, again, divided equitably, and there's certain case law that if the parties will not resolve things 50-50, there's certain case law that can guide us. One of the cases is known as Sparks v. Sparks that will contain our spousal support factors. We talked about fault a little bit earlier, and this is where you could find fault actually at play in a Michigan divorce in equitable division and how spousal support is decided. Types of property that are considered marital could be actually any type of property. So real property would include your house, your cottage, any property that's attached to the ground. Personal property is property that is movable property. So either categories of property can be divided in the state of Michigan. And it really depends on where do you start? You start with the analysis of asking yourself, is this marital property or is this personal property? So, what was the property obtained before or after the wedding? If it was obtained after the wedding, you're looking at most likely marital property unless you could fit it into some sort of exception. Property that does not get commingled or is gifted or is inherited and it remains separate from the marital estate, that separation from the marital estate really is key. If you get an inheritance from your mom and dad, God forbid if they pass away, you will take that inheritance if you do not want it to be marital property and put it in a separate account. Put it in an account that your spouse will not touch, will have nothing to do with the marital business. The division of a marital home in the state of Michigan is actually handled very logically. And the analysis really is no different than how other property is divided. So you would look at and ask yourself, when was the marital home purchased by the parties? Was it owned by one of the spouses before the marriage? If it was, did the spouse place his spouse on the deed? He would have then, or she would have then at that point just taken sole property, in this case a marital home, and turned it into joint property. 9 times out of 10, if not 90 times out of 100, in a divorce in Michigan, if parties cannot decide what to do with the marital home, the judge is going to order it to be sold and the proceeds split 50-50. And it's always better to come to resolutions rather than have a judge impose those resolutions on you. How are business interests divided in a Michigan divorce? Again, not too differently than other pieces of property. A person's business will be marital property. There's going to be a business account typically. During a divorce, if the business owner has X amount of dollars, so let's say in his business account. So his business account is a marital account technically, unless there's an exception to it somehow. The courts will, if the parties don't come to a resolution, will allow one party or the other to invade the business accounts and to conduct discovery and to find out how much money, how many liabilities are in those business accounts, and the courts will divide them up.